Judgment in the appeal Salvesen against Riddell and others. The Lord Advocate intervening.
Section 29 of the Scotland Act 1998 provides that an act of the Scottish Parliament is not law so far as any provision of the act is outside the legislative competence of the Parliament. The issue in this appeal is whether Section 72 of the Agricultural Holdings Scotland Act 2003 is outside its legislative competence because it is incompatible with a landlord's rights under Article 1 of the first protocol to the European Convention on Human Rights relating to the protection of his property. For much of the post-war period, agricultural tenants enjoyed indefinite security of tenure under statute. But the practice had grown up of granting new agricultural tenancies to limited partnerships constituted under the Limited Partnerships Act 1907, in which the landlord or his nominee was the limited partner and the tenants of the farm were the general partners. When a limited partnership is dissolved, the remaining partners cannot carry on the business of the firm. If it relates to a lease, there ceases to be anyone who can claim to be the tenant. By dissolving the limited partnership, the limited partner was able to terminate the tenancy to enable the landlord to recover possession without going through the statutory procedure. Landlords were reluctant to let agricultural land on any other basis, and the practice of letting to limited partnerships became widespread. But it came to be recognized that a new system was needed to give security of tenure to tenants, and that the granting of tenancies to limited partnerships should be abolished. That is what Section 72 of the 2003 Act aims to do. Subsection 6 of Section 72 provides that if the limited partner serves a dissolution notice after 16 September 2002, the tenancy continues to have effect, and the general partner becomes the tenant under the tenancy in his own right, if he gives notice to the landlord as required under the subsection. If the dissolution notice is served between 16 September 2002 and 30th June 2003, the landlord can apply to the Land Court for an order that Section 72(6) does not apply. But the Land Court can make such an order only if it is satisfied, A, that the dissolution notice had been served otherwise than for the purpose of depriving any general partner of any right derived from the section, and B, that it is reasonable to make the order. Subsection 10 of the section provides that where a tenancy continues to have effect by virtue of subsection 6, and the dissolution notice was served on or after 1st July 2003, Section 73 applies. Section 73 allows the landlord to terminate the tenancy at the end of its term by giving intimation of his intention to do so and then serving a notice to quit. It is this section which is favourable to landlords, and the conditions for its application in Section 7210 that gives rise to the devolution issue in this case. Peaston Farm near Ormiston in East Lothian was subject to a tenancy held by a limited partnership to which the general partners were Mr. Riddell and other members of his family. Mr. Salvesen purchased the farm in 1998 and became the landlord. The limited partner's rights were assigned to his nominee. On the 3rd of February 2003, the limited partner gave notice to the general partners that the limited partnership, which was to run until 28th November 2008 and from year to year thereafter unless dissolved, would be dissolved on 28th November 2008. On 12th December 2008, the general partners gave notice to the landlord that they intended to become the joint tenants of the farm in their own right. Mr. Salvesen then applied to the Land Court for an order that Section 72(6) did not apply. He said that his intention, when he bought the farm, was that when the tenancy came to an end, it should be amalgamated with other farms that he had in hand, and to farm everything as one unit. The Land Court was not satisfied that the test for such an order had been made out. Mr. Salvesen then appealed to the Court of Session and obtained leave to raise the devolution issue, which is now before the Supreme Court. Although the underlying dispute between the parties to the lease has now been resolved, following the tragic death of Mr. Riddell, the question whether Section 72 is incompatible with the landlord's Article 1 rights is a matter of general public importance. The Supreme Court unanimously allows the appeal on the devolution issue. It finds that Mr. Salvesen's Article 1 rights were violated by Section 7210 of the 2003 Act, and that this provision is outside the legislative competence of the Scottish Parliament. Article 1 is, as the Lord Advocate conceded, engaged in this case. A measure designed to deal with a large number of dissolution notices that were served on the 3rd of February 2003, as was done in this case, to anticipate the legislation, can be said to have had a legitimate aim. But landlords who served dissolution notices during the period between 16th September 2002 and 30th June 2003, like Mr. Salvesen, are in a worse position than those who served their notices from 1st July 2003. The benefit of Section 73 was regarded in the latter case as an appropriate counterweight to the benefit that was conferred on the general partners by Section 72(6). The Court is not persuaded that the difference in treatment between this group and the landlords of continuing tenancies who served notices from 1st July 2003 can be justified. The provision is discriminatory, and it is hard not to see it as having been designed to penalise landlords in this group retrospectively. For these reasons, Section 72 can be read only in a way that is incompatible with the Article 1 right, as the Inner House held. But the incompatibility arises from the fact that Section 72(10) excludes landlords of continuing tenancies from the benefit of Section 73 if their notices were served between 16th September 2002 and 30th June 2003. So the Court has decided to limit its decision about the lack of legislative competence to that subsection only, and it is in that respect that the appeal is being allowed. The Court has power to make an order removing or limiting the retrospective effect of its decision on incompatibility, but it has decided not to do so. A long period has elapsed since the legislation came into operation, and there are competing rights and interests on both sides which will need to be considered. Decisions as to how the incompatibility is to be corrected in the best interest of all parties, for the past as well as for the future, must be left to the Parliament, guided by the Scottish ministers. An order will be made under the Scotland Act suspending the effect of the Court's finding for a period that will enable that process to be carried out. The Court will now adjourn.